You want to protect your business and make more money? Welcome to Learn from a Lawyer, the podcast where legal protection meets smart strategy and your next level of income is built on a rock-solid foundation. I'm your host, Lauren Buckner, attorney, business strategist, and guide for women entrepreneurs ready to scale smarter and build lasting success. Let's get started. Have you ever signed a contract and thought, this sounds legal, but thought at the same time, is this actually protecting me? Has this happened to you? Listen, many business owners use contracts that sound official all the time, but the contracts don't really do enough to protect their businesses. In this episode, though, I'm going to break down what actually makes a contract fully protective, right? That big brother type of contract that we all need. And I want to show you how you can make sure that your agreements actually have your back. If you're running a business, you're probably dealing with contracts every day. Well, let me just say, I hope that you are dealing with contracts every day. But here's the thing. A contract isn't just a piece of paper. It's a tool that should protect your interests and outline your rights clearly. Sometimes it doesn't, though. And today, I'm going to show you how to turn those legal sounding contracts into ones that really work for you and not just against you. Many entrepreneurs overlook contracts or assume that a basic agreement will probably be enough to protect them. Okay, ask yourself, you've seen a piece of paper come across your desk or come to you with some terms on it and some words and some blanks for you to fill in, and you signed it and you thought, hey, this is probably enough to protect me, right? Just be honest, okay? But a contract is only as good as the details that are inside the contract. And that is what we're going to talk about today, okay? Without the right protections, a contract can leave you exposed. Without the right words, it can really open you up to a lot of liability. And that's why it's so crucial for you to understand what should be in your contracts to safeguard your business, to protect your money, and so that you can avoid mistakes and prevent disputes, because a lot of these things can be really, really costly and take your business down. So let's break it down right now. I'm going to walk you through the key elements that make a contract airtight, and I'm going to show you how you can ensure that your agreements have all of the necessary components to actually protect you and your business. All right, so this is where you take out your pen, your paper, or your laptop. I'll wait just a second. 1, 2, 3. You got what you need? All right. Let me first say that all contracts are unique to the businesses that they serve. And I'm telling you this because on these streets, a lot of times people are sharing agreements, sharing contracts. And you may say, listen, we do the same thing. We have the same business. We can use the same contracts. I'm going to say it again. All contracts are unique to the businesses that they serve. There's not one contract that's going to always be the same, right? So no one's contract is going to be the same, and it shouldn't. But there are 5 elements that every contract should have in them to truly protect them. And we're going to go over those 5 things now, all right? The first thing that every contract or agreement has to have: clear terms. I mean, that really kind of goes without saying, but I see on a daily basis, contracts, agreements come to me from clients to review or come to me from other parties that I'm doing business with words on the paper. Right? Stay with me. Words on the paper, but the terms are not clear. There's ambiguity in the contract, and that can lead to so many misunderstandings. And most often, that's what leads to disputes, right? Problems. So make sure that your terms and your contracts and your agreements are clearly defined and that they are easy to understand. And when I say that the terms are clearly defined, you've seen a contract or agreement where there's a word and there's the word starts with a capital letter, or the word may be in quotes or parentheses, or it's bolded. That usually means that is a defined term, and somewhere in the document there should be a definition that gives you a definition of the word or context as to how it's being used or applied in the document or the agreement, all right? So make sure that if you have terms like that need to be defined, that they are defined so that everyone has a clear understanding as to what is happening in this or in the document that you are using for your business. Always remember, Clear communication, that's what comes from our contracts and agreements, and that is what leads to the money. Clear communication leads to the money. It leads to either making the money, protecting the money, or growing the money. Clear communication, clear terms. Got it? Is that clear? All right. Number 2, payment terms. Now, we're talking about right now the key terms that should be in agreement, and this is assuming that this is an agreement that is for service or products, right, where you are accepting money. So payment terms should always be in those types of contracts. You always want to specify how much the service is, how much the product is, right? When do the payments need to be made? Very, very important. How will the payments be made? Like, how do you want to get paid? And you can be very specific, and you should be very specific, because when you are doing business with clients, with vendors, with whoever's on the other side and they owe you money, the more clear you are with your terms, the higher chance that you will get paid on time. And that is why we're all in business, to make money. So we want to make sure that we don't just get paid, but we get paid on time. As they say right now, run me my money, okay? Run me my money and run it to me on time. So let me just tell you how much, tell you when you need to pay it, and how you need to pay it. I'm going to be really clear. You also want to make sure that you include details on late payments and what penalties that you have in place to protect yourself. Life happens. We've all been late on a payment. I mean, I don't really want to say right now I probably am late on a payment, but we've all been late on a payment, whether they be a small payment or a big payment. So you want to make sure that you include details on late payments in your contracts and your agreements for 2 reasons. 1, so that you know exactly what it is that you are expecting. And 2, so that they know exactly what it is that you are expecting. So this is forcing you to get clear on your process. So you want to make sure that you include all the details on late payments and whatever penalties that you are going to put in place. Super, super, super important. So just for example, I'll just tell you a little bit about how my processes are in my documents. And I want to spend a little time here because I think this is also a key portion of documents and agreements where people get lost. And for some reason, people are weird, business owners are weird talking about money, and I'm not sure why, okay? So in your documents, it's okay to actually talk about what happens if someone doesn't make your payment. So in my agreements, right, it talks about how much it is to work with us. So it depends on if you're coming in as like a straight consulting client where you're here for 6 months or longer, and so we have a different kind of payment plan, or if you're coming in as like a billable hourly client, right? So we're just going to assume that we're talking about someone that is coming in as a consulting client. So they're going to be with us 6 months or longer, and they have a large lump sum payment that we break up for them over several payments. In our documents, we require that very first payment to be made as soon as you sign your contract. This is before we've done any work. So you're paying ahead of time that first payment. Why? Because if I don't have that first lump sum in my hands, I know that you're probably going to be a problem. And I've had to learn the hard way, right? So this is why I require that first payment up front. And then every payment thereafter is paid at the top of the month that you're going to receive service. So not at the end, not after we've done the work, at the top. In our documents, we allow you 3 days to be late, and it's specified in there. You have a 3-day grace period. After the 3rd day, we start to email you, we call you, and we start to assess a late penalty. By day 5, we have now assessed you a 5% late fee. I'm not playing with you. I'm going to need my money because I'm going to give you your services on time, right? If you then don't pay, day 15, you go to pins down. Actually, I take that back. Day 5, pins are down, and we're really in our email campaign. 15 pins are not just down, but you're on pause. We only give you 15 days. We're not playing around. Day 30, if you have not paid your invoice for the money that you owe, you are now in our collection cycle, and we have a whole collection process. We're going to get the money, and then we're not doing any other work after that. That's all outlined in our documents and our agreements so that you understand, right? Notice, pause, pre-collections, collections, go get your money. Make sure you create a plan and you create that plan to stop the bleeding early. You notice I give you just a second to be late, and then we put our pins down. A lot of business owners are out here, oh, I'm just really kind of afraid. I know they said they're going to pay, and well, they might pay, and I'm still going to keep working. Don't. Don't keep working. Stop the bleeding. Don't let the client run up thousands and thousands of dollars on you and you're still running after your money. You give them a few days. And if they don't run you that money, you start running them service. Capiche? Capiche. All right. Another thing really quickly while we're talking about payments, let's talk about small claims court. So you're going to hear this come out of my mouth a lot. When I say run me my money, I'm serious. A lot of business owners, maybe even you, just leave money on the table. You allow people to ghost you. You allow people to say, hey, I'm not paying this invoice, and you do nothing about it. I don't get that. There's this concept called small claims court, and it was created for you, for me, for us, for we, so that we could get what we are due. So if you have a contract and someone is not performing their part of the bargain, and they have not paid you your money, and if it's about $10,000 or less, you can take them to small claims court on your own. You don't need a lawyer to go with you. You just need strong documentation to show that you had an agreement, which of course you're going to have an agreement because, hey, that's what I'm teaching you here. Your agreement is going to have clear terms in it. Of course, that's why I'm teaching you this, right? And then you would have done the work that you said you were going to do. And I know you're going to do that because you move in the spirit of excellence. And so all you have to do now is show that they did not pay you according to the contract that they signed. You can take someone to small claims court. It costs you nothing actually, but your time. But guess what? Your time is valuable. So the time that you also put in creating whatever you did for them, I want to be compensated for that. And I know you want to be compensated too. So small claims court is accessible to you. This is something that you should build into your collections process. Remember, I said we have a collections process. It's two-tiered for us. One is if the bill or the invoice is $10,000 or less. The other is if it's $10,000 or more. Fortunately, we've never had to use the $10,000 or more because, like I say, I stop that bleeding very early. If I see that the first couple of dollars don't come in, I'm just not putting any more work into your project or your matter, all right? So I want you to understand that small claims court is your friend. I just want to tell you that, all right? I don't, work for them, but I love them. Number 3, you need to have a dispute resolution clause in your agreements. So this actually kind of falls right in line with small claims court because things are going to happen. So you have to include a clause that helps define how disputes are going to be handled, whether that's going to be through mediation, arbitration, or litigation, and where you're going to settle those disputes. So let's get smart here. I like to break things down for you in case it's a little much, because I think a lot of people don't understand what mediation and arbitration are and what the differences are. So let's talk about it so you can make sure that you're selecting the best route for your business that you're building into your documents. So first of all, mediation. Mediation is like, back in school when you had a problem on the playground, the teacher brought you and Billy over and you had to talk about it. It's a collaborative effort, right? So you have a collaborative, informal process, and it's going to be led by a neutral third party. In some documents, you can select upfront who that mediator is going to be. It can be a company. It can be a person. You can go to different, not clinics, but there are different services that provide mediation. So you can select ahead of time who your mediator is, or you can just select ahead of time that you're going to use mediation, and then down the line, find who that mediator is going to be. But the key here is that both sides are working toward a mutually agreeable solution. All right, you're going to use this when you really want to preserve the relationship and avoid court. So maybe this is someone or some entity that you might want to do business with again down the line. Maybe something just bad happened here, or maybe they have a good relationship within the industry that you're in and you don't want to ruffle feathers, even though they might be the one, at fault. But you still kind of want to leave, with a positive note. On a positive note, and you want to avoid court, which can be costly and take a lot of time. The second option that I talked about having in your contracts for dispute resolution is arbitration. So arbitration is a private legal process where you also still have a neutral arbitrator, but the arbitrator is making a binding decision. So that's the big difference, right? So mediation, it's mutually collaborative. I'm not saying it's all like, roses and everything, but both parties pretty much want to get to a common point and will work together. Arbitration, you still want to get to a good resolution, but you're just not going to sit in that room and kind of, kumbaya out. You're going to really try to work it out. And that's the arbitration. So you got a private legal process. Someone's probably trying to get a win. Someone's probably going to lose something. This is in negotiation, we call this a distributive process. So there's just a small amount of value that's available and someone's going to get a larger piece, where mediation is more of an integrative type of style of negotiating where everybody wins on both sides. All right. So you're getting real smart here. I'm just breaking it all down for you. Okay. So arbitration, though, is it's a fast procedure as well. It's less formal than court. And the other thing, though, is that you can't appeal it. So even though it's binding and it's a legal process, you cannot appeal the decision that the arbitrator makes. So this is often used when it's spelled out in contracts. So you'll either see mediation or arbitration, or you'll see just straight litigation, the regular judicial process. And of course, that's the formal court process that involves judges, legal pleadings, attorneys, public records. This is where you start to spend money. And you use this when you have negotiations that have just failed. Maybe you've tried arbitration or mediation and just didn't work, right? And you need legal enforcement. But again, you need to be prepared to pay for it. There's higher costs and it takes a long timeline. Okay, so now you're really smart on dispute resolution. Think about your contract. Start thinking about them right now and start to think, do you have a section in there about dispute resolution? Do you have one? What is it? Is it something that's just been in your documents and you actually never knew what it meant? And then do you agree with what it says? Right now, you can go back and make changes. Remember that contracts are living documents. You should always revisit them and change them, revise them according to your business at that time. All right. Number 4, we got into this agreement. How can we get out? Termination clause. You got to have a termination clause. Make sure that your contract includes crystal clear terms for how either party can end the agreement, including the notice that's required and the reason for the termination. Now, listen. When I work with clients and in my own contracts, I like to have language that allows termination for any reason upon 30 to 45 days written notice, right? I like to have those in client contracts, of course, along with the standard language that gives you the right to terminate at any time for a breach of material terms. And the reason I like to have that option where any party can terminate at any time for any reason is because I don't want somebody to be stuck in a contract, right? I've been stuck in those contracts. Back in the day, signed contracts, didn't realize I couldn't get out of them, and I wanted to get out and I couldn't get out, and I had to consistently, pay money. These were, programs and stuff like that. But still, I wanted out and I couldn't get out. Vice versa, I don't want to be serving someone who doesn't want to work with me. Right. And I also have had times where I don't want to work with people. I have fired clients. So I like to include that provision. You don't have to, but I like to include the provision that gives either side the chance to just terminate 30 to 45 days notice. That gives you enough time to find a replacement. It gives you enough time to kind of, recalculate your budget if that was a big piece of change that was coming in. But, that's just my opinion, right? But you always want to make sure that the notice is given in writing. And you want to specify how. Do you want the notice to be given to you via email? And if so, make sure you include your email address in the document. And if you happen to update your email address, it's your responsibility, though, to notify the other party that your email address has changed. Maybe you want to say, listen, I want you to go the old school way and write me a letter and put it in the mail and mail it to me. And that is okay. Then you need to make sure that you supply your mailing address in the document. And again, if you move, you need to make sure that you notify them of your new address. If you don't give them the new address and you're requiring notice be sent to your address if they want to terminate and they do that and you don't get it, then that's on you. All right. Number 5, liability protection. Oh my God, this is so crucial. It's so crucial. Your contract has to outline who's responsible for what, for damages, who's responsible for liabilities, and who's responsible for making any indemnifications, making sure that you are not left holding the bag. So let's get smart again, because this is a section, I'm going to be honest, where people, I'm not saying you, because I know you would never do this, delete. I have had business owners come to me and ask me to review a contract that they've actually already reviewed, which is good. You should always review your documents first so that you can understand what's in them. But they've asked me to review their documents, And I can tell they've been revised. And I'm like, was there damages section here? Was there a X, Y, and Z section here? And they're like, oh yeah, I took that out. I didn't need that. And I'm like, yeah, you did. So this here, your liability protections that are built into your documents are so important, and they're not just wasted language. I know a lot of times, and I'm gonna be honest, I think maybe if I wasn't a lawyer, I too would be like, I'm deleting this. This don't even make sense. The law is antiquated. It's old. The concepts are not known by everyone, which is why people have issues every day surrounding the law, because most people don't understand the law. But this is a document, a body of governance and codes that really do govern our lives, and most people don't understand them, right? So listen, I know that this is a common issue. So I'm not, knocking anybody who doesn't get it, but I am saying that you've got to understand it. So let's talk about it. Damages. When we talk about damages, when it comes to contracts and agreements, we're talking about the money that one party may owe another party if they breach a contract or cause harm. Breach means you violate. So if you violate a contract, if you violate a provision in a document, or you cause somebody harm, damages relates to the money that one party may owe another if they breach or cause harm, okay? So I just want to make sure that is clear. So think of this as the price tag for breaking the rules or causing a loss. So don't break the rules and don't cause a loss. Liabilities. These are your legal responsibilities or potential risks. So in documents, you'll see sometimes it just says you may be liable for any liabilities. And you'll be thinking like, well, liable for any liabilities, what does that even mean? Delete. It doesn't even make sense, because it sounds like it doesn't make sense, but it does. Liable means responsible. Liabilities means you're responsible for your legal responsibilities or your potential risk. Like if your product causes harm, or you don't fulfill a part of your contract. It's what you can be held accountable for. Does that make sense? I hope it does. If it doesn't, drop it in the comments. Say, hey, it didn't make any sense to me, and I will try to respond to you, all right? The other provision, and this is the provision I think is the one that gives me the most angst, because people really do delete it, and it's the indemnification provision. You want to have this in your document. So when you start looking at your documents, I want you to try to see, do you have an indemnification clause in there? Have you deleted it? Right? If it's in there, do you understand what it is? An indemnification is a promise to cover someone else's losses or legal costs if something goes wrong. Let me say it again. Indemnification is a promise to cover someone else's losses or legal costs if something goes wrong. So this is often in contracts, right? So like when a vendor agrees to hold you harmless if their work causes a lawsuit. Have you heard of that? They're going to hold you harmless if their work causes a lawsuit. I know you've seen that language in a document, and I know you had no idea what it meant. And you're like, what? They're going to hold me harmless? What? Right. That means they are going to indemnify you. They're going to pay someone else's cost, your cost, if something happens. All right. So let's do a real life example here so that this really can sit with you. Okay. So let's say you hire a web designer. You hire a web designer to build your new e-commerce website. Okay. Ooh, exciting. You launch it, but a few weeks after you launch it, a customer sues your business because the site crashed during a checkout and they lost their money. Ooh, man, that sounds like that really can happen, right? Now, here's how these terms then would show up in this situations, right? So you hired a web designer to create your e-commerce site. A customer was on there. They paid some money. The website crashed. The customer lost their money, and now they are suing who? They're suing you. So the first thing, damages. The customer is going to sue you for $10,000 in the lost sales. So they paid $10,000 into your system. The system crashed. They lost their $10,000, and they are pissed off, and they are suing you for $10,000 in lost damages. That's the damages that they're claiming that your business caused. Okay, dang, I get it. Liabilities. Your business could be liable for the harm that it caused, that was caused by your faulty website. So especially if you didn't test it or you had no disclaimers on it, you could be liable. So that could be another number that could be attached to you. But here's where the indemnification kicks in. If your contract with your web designer includes an indemnification clause, it might say that they are responsible for covering your legal fees and for any damages if the problem was caused by their work. This means that they hold you harmless. So it goes all the way back to that concept. This means that they have to hold you harmless and possibly they have to pay to fix it. Are you still with me? You still here? Indemnification. So important to have these provisions in your agreement so that you are not left holding the stick at the end of the day if something happens because of someone else's services. Now that you know what should be in your contracts, let's really quickly talk about how to make sure that these elements are actually in the contracts, right? So you know what should be in there. Let's make sure that they're actually in the contracts. Here's how you can make sure that those protections work for you. So number one, really quickly here, make sure you're still writing. Review your contracts regularly. Don't just sign them and forget them. Take time to review your contracts periodically and make sure that they actually reflect your current business needs. I love the charts. I talk about it all the time. Make a chart, set a calendar reminder for you to do regular contract check-ins. And you can also give this to your staff to do. Like, you don't have to always do all of this work. Delegate, delegate, delegate. Number two, consult with a legal professional. You cannot draft your own contracts. Nope, you can't. You should review them at the beginning so that you can understand, right? So here's where the line is really drawn between real business owners and hustlers. If you're using a legal professional, never sign a contract without having it reviewed by an attorney. Never, never, never. Say it with me. Never. Okay. And again, you're never going to draft your own contract. It's okay to use templates. You can even create your own templates. I create templates for clients all the time so they can have a document that they can use again if the situation that's similar to this presents itself. But if they have to start to change provisions in the documents, they know that they have to call me and say, listen, Lauren, I'm thinking about changing more than 3 or 4 words. I think we actually kind of have if you have to change more than 3 or 4 words, you need to call me. Okay. And then I need to look at it. But it's okay if you have templates that you use them, right? But make sure that the templates are created by a licensed attorney so that you at least have a framework. And the attorney should be someone that specializes in contract law or business or the subject matter that's in the document. All attorneys are not created equal. Okay. I mean, there's a lot of attorneys out here that do a lot of different things, and everybody should not be reviewing your contracts. And I just want to be very, very specific about that. All right. So you've got that down. Number 3, keep your contracts organized and accessible. So again, go back to what I talked about. Just make a chart. Make a chart, document your contracts, know when they start, when they expire. Make sure that you store them in an easily accessible place. If you still have paper documents like I do, which is okay, make sure you have folders that are labeled and everyone knows how to get to them. Make sure those documents also, though, are scanned in somewhere, and you have a system that will still be around if the internet crashes, right? So meaning it's the things are in the cloud, as the kids say. Make sure it's in the cloud, and I am still antiquated, and I back up with a hard drive. So make sure that you can get to your contracts when you need to so that you can track your deadlines, your payment terms, and your renewal dates. Did somebody say chart? I said chart. Now, let's implement my favorite part. Take out your contracts. I want you to look at your current contracts. Are they missing any of these protective elements that we just went through? Any of them? If they are, this week I want you to just, focus on one contract. And then I want you to focus on the provisions that are missing and talk to your attorney about it. All right, whether it's a contract with a client, whether it's a contract with a vendor or a partner, I want you to review it with these elements that we talked about today in mind. And if it's missing any critical protections, do not just close your eyes and walk away. Now is the time seriously to speak with your attorney and make those necessary adjustments. This is what we call taking action. Take action. All right, so if you need some help, just drop your questions in the comments below and I will respond. right? You can also book a complimentary consultation call with me. Just click the link that's in the show notes or scan the QR code on the screen. It's important for you to get what you need for your business. I hope this episode helped you feel more confident about your contracts and gave you some practical steps to make sure that your agreements are protecting you and your business and your money. I know it was a lot to just go back and listen to this again and listen to it again, but I hope that you got something out of this episode that's going to help you build a stronger business. Next time, we're going to go deeper into how to protect your revenue when clients ghost you. Oh my God, that's the worst. But anyway, be sure to subscribe, leave a comment below, share this episode with your business besties, and tune in next time. Thanks a lot. I'll see you later.